Welcome to Beyond the Gavel, the podcast where we explore the intersection of law, medicine, and justice through candid conversations with some of the most experienced and insightful professionals in the field. Today I'm joined by Kashmir Uppal, who's a partner at Shoosmiths, and she has an exceptional track record in clinical negligence litigation. She's widely recognised for her work on complex, high-profile cases, many of which have redefined standards of care and professional accountability within the medical profession. She brings decades of experience, particularly in representing claimants in cases involving surgical error, delayed diagnosis, and systemic failures in the healthcare industry in general. So her work has extended beyond the classroom and the courtroom, influencing policy and public perceptions in landmark cases that have gone to national headlines. So in this episode, we're going to delve into nuances of medical negligence practice in the UK, the evolving role of solicitor in patient advocacy, and the challenges faced when these cases edge into criminal territory, a space that Kashmir knows only too well. So Kashmir, thank you for joining me today.
Thank you for inviting me to join you.
You're very welcome. Now, you've been involved in a number of very high-profile cases within the UK, and it has resulted in changes in legislation. And I know also that you like to work closely with the GMC, but one of the things that came up was that, for instance, on a particular high-profile case, the guy was allowed to keep working for about 5 years as the GMC would take no action over that time. So what do you feel from a lawyer representing, plaintiffs with somebody that may be, because I haven't been to court yet, responsible for a number of cases with no real action apart from a bit of supervision being taken before there's a judgment?
I think where there's a situation where there is a number of claimants raising the same concerns regarding a consultant or a doctor, because of the number of people involved, then more serious action needs to be taken, because it's not just an isolated incident. If all of these individuals are concerned about the treatment that they've received, and there's genuine concerns about that, then the General Medical Council should have a position whereby they can stop that doctor practicing, even if at that stage there was not enough evidence to support the allegations. Because if it transpires at a later stage that actually those allegations were correct and proven, there's been a loss of an opportunity whereby the actions of that doctor can be controlled or stopped and protecting the public. At the moment, I think the GMC, in terms of the balance, is a bit more in terms of protecting the doctor rather than protecting the public. And I know it's a very fine line, because often allegations are made against doctors in terms of their fitness to practice, and they're not actually proven. And if the GMC acts, then their professional position is impacted, their income and their employment and their financial situation. But I think the frustration that we had with the Patterson case that we're talking about is that it was the number of claimants who all had the same allegation that they were subjected either to the wrong type of surgery or unnecessary surgery, and it just took a long time for the GMC to take steps. When they did take steps, they imposed conditions on his registration, and then they did suspend him, and then he was struck off the back of the criminal conviction. And as I say, I appreciate that it's a difficult and a fine line for the GMC, because they've got different interests that they're balancing. But I just think that maybe there needs to be a review of the GMC in terms of the sanctions that they can take, and the point that they can take those sanctions, to make sure that there is more of a public protection where there are concerns regarding an individual doctor's practices.
Well, when you first saw that, when you first took on your first case in this, were you thinking criminal or were you thinking civil?
Initially, it was just civil. I didn't appreciate at that time in 2009, when I took on the first case, how big this was going to be. I thought that this was an isolated incident of an incomplete mastectomy, which had then resulted in a recurrence of that breast cancer, which then resulted in the lady having to have further surgery, and also to having other preventative surgery such as hysterectomy. by chance, I got instructed in another case where the issue was exactly the same. And I did think, gosh, that is that a coincidence that the issue exactly the same, or is there something more to this? And at this point, stories were coming out in the local media about this cleavage-sparing mastectomy procedure that this doctor was carrying out, and it became apparent that the reason why these two women had incomplete surgery is not because of negligence in the traditional sense. It was because of a deliberate act to perform incomplete procedures. However, the criminal prosecution in that case was based on unnecessary surgery. So women predominantly in the private sector who were presenting to him with a breast lump, which was tested and turned out to be benign, but he was misrepresenting that and saying it was precancerous, or he was saying it was cancerous, and then they would have to have surgery.
So we have two things there, don't we? In the private sector, the one you're talking about, there was a deliberate mens rea, there was a deliberate, attempt to get money from people.
Well,
in the civil one, which you first get, that what was the difference? Would you say that was criminal, or was it just incompetence, or what way was that balance? Because from the GMC, there's a difference between incompetence and criminality. So when did you see it crossing the line into criminality?
Well, in terms of the criminal proceedings, they all of the charges related to unnecessary surgery within the private sector. So the criminal proceedings didn't deal with the cleavage-sparing mastectomy procedures that were predominantly carried out in the NHS. There was the allegations were wounding with intent. It wasn't about taking proceeds of his crimes. But as I say, the issue of the cleavage-sparing mastectomy was never subjected to criminal proceedings.
So you were taking two lines there, where obviously one goes through the police and the Crown Prosecution Service, and then the other one. So you had two tracks running at once, and how did they interact?
Well, we actually probably had three tracks running, because we had the civil proceedings. So every client that presented to me, I was pursuing a claim for them, either for having an incomplete mastectomy and then having recurrence or further surgery to remove that breast tissue, or having an operation that they did not require. So that was a civil claim under the Tort of Negligence for having procedures that were not necessary. I was also reporting all of the cases that presented to me to the GMC, because I wanted the GMC to take action, and then also liaising with the police in relation to the unnecessary surgery, in the hope that the police would take action as well, and that the police then did eventually charge him in January 2016, and a trial took place in March, April 2017, which resulted in his conviction on 20 charges of wounding with intent.
Yeah, so I mean, there is a whole process going on there between the two, isn't that right? I know the argument sometimes. I mean, a lot of us in breast cancer did lumpectomies and maybe sentinel node biopsy. Do you feel that in that, I mean, there's then the question of, if it hadn't been for the criminality, if you split that off, a question of then doctors turning around saying, well, if I'm going to be sued for doing that, then I will practice defensive medicine and I will do more tests and more stuff. How do you feel about that, and that it's pushing doctors towards defensive medicine, which is high cost and, more tissue removed than should be removed, because they're defending themselves against the possibility of a claim?
I think the doctor's duty is to provide their patient with best form of medical treatment, and that is their priority. They should not be practicing defensive medicine. What they should be doing is looking at their patient, seeing what the patient's condition is, doing the appropriate investigations, liaising with their colleagues at MDT meetings to make sure there is a consensus of opinion in terms of the medical treatment their patient requires, and providing the patient with that medical treatment. I mean, in terms of negligence, is the Bolam test, what would a reasonable doctor do? So if it's defensive medicine, would that be that this is the gold standard of treatment because they're providing far more investigations than would otherwise have been required? So I don't think doctors should practice defensively, because they shouldn't be thinking about that they're going to be sued. That shouldn't be they should be thinking about treating their patient and treating the patient's symptoms and making sure that they follow the correct procedures, and consult with the correct colleagues in making the right decisions for their patients.
Yeah, I think that's very powerfully put. So when this case came out, there were, I think, 11 recommendations, and they weren't all implemented, were they? So what's your thoughts about that? What were the most important of those, and which ones do you think should have been implemented and weren't?
I mean, one of the issues in relation to private surgery was the issue of indemnity, because the doctor was insured by a private medical defence union, and unbeknown to me, that these policies are actually discretionary, so they withdrew the cover. And so in those circumstances, we had to find another defendant to sue, because otherwise there would be nobody who could be held responsible in terms of indemnifying. The particular circumstance of this case is that the private hospital had been made aware of the concerns regarding this doctor by the NHS, and therefore we could make arguments that there was a non-delegable duty of care and that there was an element of vicarious liability. But those issues were never tested at trial, because the case was listed to go to trial in October 2017, but terms of settlement were agreed in around September 2017. So the issue of whether a private healthcare provider is vicariously liable for the acts or omissions of a doctor who's given practicing privileges at their hospital remains that no, they're not. But that means that if this case didn't have the particular special circumstances of the knowledge of the private healthcare provider, then the private healthcare provider could have said, we're not at all responsible for this, and therefore there would be nobody to indemnify. So one of the issues was looking at the indemnity position of private doctors, and whether that should be the schemes that are discretionary, there should be no element of discretion there. So that if you go into a private hospital and things go wrong and you suffer an injury, you don't have to worry about is there anybody there who's good for the money, in terms of if you pursue a claim and you are claiming compensation if you can no longer work, for example, and you can't pay your mortgage. You can't be in a position whereby you've suffered that injury due to no fault of your own and there's nobody there because there's nobody good for the money, because there's no indemnifier there. I think that's one of the most important things. The other thing is about the sharing of information, that there should be a database where all of the information regarding a doctor is available to a member of the public, so that they make informed decisions about who they are being treated by. So if there's concerns about the doctor, that should be available, so that the patients are not kept in the dark about any issues that have happened with their consultant previously.
Mm-hmm. I think that's true, and I mean, yeah, the main providers of insurance for doctors, such as, I mean, medical defence union, it is discretionary and they can withdraw, and that's a problem. Do you know, most doctors don't realise that. Most doctors have no idea that they're not going to be covered. And there are other insurers out there. I'll be speaking to somebody in another podcast very shortly about their levels of cover versus some of the defence unions. But doctors just do not know. This is, I mean, everybody knows the major couple. And, you know, they've been baited and dined when they were young doctors by these people. They've signed on saying, well, I have insurance, I have indemnity. And then it's withdrawn. So it's not just I think it has to be made more clear, and some of these insurance companies need to be put on notice that it's not acceptable, that they are discretionary cover and that they can withdraw it. I totally agree with you. So what advice would you give to others coming in? You know, you have people coming to you to join you into medical negligence. What do you think for a young lawyer coming in? Do you think it's a good run to go, and how should they set about getting the experience in medical negligence cases?
I mean, I think medical negligence cases they're fascinating because you're dealing with areas of medicine, but you're also dealing with individuals, and you're trying to obtain redress for them so that they can get on with their lives when often they're being catastrophically injured as a result of medical negligence. For example, in obstetric cases, children suffer catastrophic brain injury, or people have other types of very serious injury. So it's an incredibly interesting area of law. I think moving forwards, though, the considerations that are of concern relate to costs in terms of the um, instruction and the introduction of fixed costs for some cases, whereby you're going to be limited in terms of how much you can pay your experts. You're going to be limited in terms of the extent of the investigation that you can carry out. So proportionality is another issue that's often raised by defendants in relation to clinical negligence claims. So it's a difficult one because there is pressure in terms of the amount of cost recovery that you can recover in these cases, but often it takes a lot of time and a lot of cost to investigate the case. And obviously legal aid is now very, very limited. And we find that even with neurological injury cases for young children, the legal aid agency can often say no, that they're not prepared to fund it at that stage. So funding, I think, is an issue. Proportionality of costs is an issue. But it's a really interesting area of law, and I think if somebody wants to get into it, they have to show that they are interested in it by going and helping charities, for example, where they're working with people, for example, cerebral palsy, or going and working in a hospice to show that they have got a connection with patients and situations where people are in distress. Because a lot of our job is about empathy and compassion and understanding and having those people skills to make sure that people who have been very severely injured and let down by one professional and put their trust in another professional to make sure that we can achieve the right outcome for them.
Yeah, and how do you deal with the emotionality of that? I mean, those cases were quite sad, some of the ones that you were dealing with, and a lot of cerebral palsy and things. I mean, a lot of people get really stuck in it, don't they? And they get very sympathetic. And that means that you're putting your soul into it. And you become on the hook for it too emotionally, as opposed to empathy, where you say, I understand, I can take this. How do you separate yourself from your clients and yet help them to feel that they're cared for?
I think the best thing you can do is that energy that you get from the empathy that you have from your clients is putting that into making sure that you do the best job for them, that you make the best representations for them, that you be the best advocate for them, that you ensure that you don't leave any stone unturned in terms of the investigation. If it's liability where you're not sure about the evidence, that you review your expert's report thoroughly, you think about if the expert's if the expert is not supportive, well, what other issues can you ask this expert to consider to make sure that they have considered every single issue before deciding that they can't support it on a case of either breach of duty or causation. It's turning your empathy into a positive step to make sure you achieve the best outcome for them.
It is advocating for your client, isn't it? And being able to question your expert.
Yeah.
A lot of experts don't like being questioned. It's a bit like barristers don't like being questioned either. But a lot of experts don't like, and I think that's bad. And I think it's to do with relationships, isn't it? Between you and your to have experts who you get on with, whom you can speak to, who you can lift the phone and talk to. I mean, a number of times I lift the phone to lawyers and they don't answer, or they're busy, and I said, do you want to know about this or don't you? I mean, it's more than just something written on a sheet of paper. I want to talk it through with you. And there are a reasonable number, I would say, of lawyers who don't want to do that. They just say, oh, just write it and give it, and I'll study it then.
No, I think it's really important to have a good relationship with your expert, so that sometimes they send you a report and you think, I don't actually understand what this expert's saying. So you want to be able to pick up the phone to them and say, right, you've said this, that, and the other. my understanding of that is this. Is this correct? Is that what you meant? Or am I misinterpreting what you're saying? So it's, you need to break your expert's report down, analyze it, and go back to the expert and say, I understand why you said that, but have you considered this? Or can I just challenge you on that? And that's the best way to make sure that you've interrogated them in relation to their expert evidence, whether it's on liability or on quantum. On quantum, you wanting to make sure your expert is maximizing the compensation, the award that you can achieve for your client.
And then there's always that tension, isn't there? An expert doesn't work for you or for anybody else. An expert is for the court.
It's for the court, yeah.
And there is that tension. You are responsible for your client. If you are advocating on behalf of your client, an expert needs to stay neutral. And there's always going to be that tension. Say, well, can you not say this? Or, and the case of Safir and Khan and all the rest of it, where an expert changed and made it a bit more towards one side. And as the judge over here said, straying from the midline of the road towards the sidewalk is not a good idea. So how do you balance between, as you say, challenging them and not appearing or not giving the appearance of trying to influence a report?
Well, I'm always careful not to tell them what to say, because I don't want them to stand in the witness box and say, oh, the reason why I've said this is because the solicitor told me to say that. So you always have to make sure that you're not actually telling them what to say. You are just asking them questions and saying, what about this point? What about that point? Because at the end of the day, as you say, they are experts for the court. They don't work on a no-win, no-fee basis. They get paid for their report, whether the report is supportive or not. And they will make that clear at trial. So as I say, you have to be really careful that you don't put words in the expert's mouth, because that will come back to bite you, because inevitably the expert, when they're asked the question, will say, oh, I only said that because the solicitor told me to say that. So
so the point is more when you're talking to them by saying, I need to understand. I mean, that's sort of, I'm puzzled, or I just need to understand. I can't quite get around this, so I can't explain this to my client. Can you help me with that? That sort of approach. And it's those soft skills, isn't it? So also for a lawyer, you need those soft skills of being able to ask questions without being directly challenging. It's not in a court. It's not like a barrister going, and we all talk about that, but it's about how you relate to somebody, even within your own profession, to relate to the other side of your own profession, how you relate to people. What is it anyway? A good lawyer knows the law, an excellent lawyer knows the judge. So it's to do with knowing people and knowing what is the likelihood of things going on, and finding a nice soft way of dealing with it, getting your point across, but do it in a way which isn't confrontational or pushy, isn't that right? And then with that cooperation, I find most plaintiff and defensive lawyers actually get on pretty well together, because they work together again. So it's a matter of discussion and understanding, and I'm puzzled or I'm curious. That sort of line of soft skill helps enormously to get to where you need to be.
So if there was
sorry, go ahead.
I was going to say, it's good to have a cooperative relationship with the other side, rather than to have a acrimonious relationship with them, because you are working with the defendant solicitors. But sometimes if they don't share that spirit, then you will have a relationship where it is very combative and you're just going back and forth with points. But as I say, I always think it's better for the claim if you can have a working relationship with the other side.
Yeah, I think that's true. And I think I was going to ask you one kind of big message you give, and that seems to be one, is about relationship with your expert, or about relationships with the other side. It's cultivate your relationships with the court, so that you can get your points across in order to advocate for your client, as opposed to trying to drive a bulldozer through it.
Yeah,
so
absolutely.
Look, this has been a fascinating conversation. I hope you've enjoyed it. We certainly have. And I think our listeners will get a lot of hints from what you've been able to speak about today. So thank you so much.
Thank you for inviting me. I really enjoyed it.